My name is Gita Rasali, and I am a representative of the Conflict Victims Network living in Kathmandu, Nepal. My sister was raped and killed by government security forces. My brother was also killed. I am seeking justice for my sister and brother. The security forces invaded our home at midnight, capturing my sister. Although we couldn't witness the incident, we heard her cries and shouts, which persisted for 5 hours. This tragic event happened in the summer of 2003. Several family members who witnessed the incident were traumatized. My mother was severely traumatized and admitted to a hospital. The aftermath of the incident was particularly challenging for us, as my sister's lifeless body remained in our house for 6 days, intensifying our collective trauma. It was an unforgettable event.
Nepal has gone through a decade-long armed conflict that lasted from 1996 to 2006, where many human rights violations occurred from both parties of the conflict. At that time, Communist Party Maoist was a rebelling party, and the government security force. Many human rights violations, including the enforced disappearance, extrajudicial killing, torture, rape and sexual violence, and other serious human rights violation cases were also occurred during that conflict.
My fight for justice commenced on the day of the incident. We took the case to court, but the court didn't convict the perpetrators for the wrong they did. After that, we brought the court case to the Human Rights Committee. The committee issued a letter of recommendation to the government to give reparation to the family, but the government hasn't followed the recommendation. Despite numerous obstacles, I persist in the fight for justice, not only for my sister but also on behalf of all conflict victims who have endured similar human rights violations. Meanwhile, the perpetrators roam freely, enjoying their liberty while the victims continue to suffer. Despite the considerable time that has passed since I embarked on this journey for justice and reparation, I still maintain hope that this process will unveil the truth, shedding light on what happened and why. However, the prolonged nature of this process has left victims frustrated and disheartened.
It is reported in the recently established Transitional Justice Mechanism that more than 60,000 cases of human rights violations was registered in the Truth and Reconciliation Commission and Commission on Enforced Disappearance, but none of the cases were investigated and concluded till date. A majority of the victims have not received remedy. When the TRC Act, Truth and Reconciliation Act, was enacted in 2014, the ICJ has done its analysis of the act, whether the provisions are compatible with international standard or not, and it has published a briefing paper analyzing that act, and it has also recommended the government to make the act in line with the international standards, including remove the amnesty provision on serious crimes, and also statute of limitation, because there is a provision that in Nepali law that some cases, including the rape and sexual violence cases, has to be filed in certain period of time. Recently, the ICJ also published a briefing paper analyzing the Nepal's transitional justice legislation from gender perspective, and it has found that the gender perspective is largely ignored. In that briefing paper, the ICJ has also analyzed in detail about the sensitivity the government has to take while dealing the conflict-related sexual violence and the gender-based violence cases during the conflict.
Those papers are very clear and also referred by many. I can see also the lawyers recently. Lawyers were talking about ICJ's briefing paper because it actually provides a lot of information and connects with the Nepal's transitional justice.
And recently, the government has also introduced a bill to amend the TRC Act, and we also reached to the influential political leaders. We also did a advocacy meeting with the parliamentarian to make them aware about what was the major gender concern.
But at least for a long time, a mostly awaited bill has come. However, lots of flaws are there. It has removed the amnesty generally, but it would still be difficult to prosecute those who are responsible for serious violation of human rights and humanitarian law, of course. It does not provide special investigation unit for the specific issue. So bill does not clarify, as you mentioned, that the principle of non-retroactivity. Penal code and then our criminal law, they are very clear about that non-retroactivity. But that is for the general criminal prosecution, right? Not for the transitional justice related prosecution. Clearly, we have to say that retroactivity is immaterial. So I doubt and I have a fear that if the bill does not specify more gravity and more serious, thresholds or elements, then there may be a risk of generalizing the matter and perpetrators not really being, convicted.
And we have distributed those that briefing paper to the parliamentarian and human rights committee of the parliament. Some of the concerns that we also raised in the briefing paper are now being discussed in the parliament, including the removal of a statute of limitation and gender sensitive and gender responsive procedure.
So far I have worked with ICJ. ICJ is very active, creating and closely watching court's judgment, and also forming the working group for study. Parties to the conflict are in power, and it is always very important to create impact by releasing some statement and as a watchdog.